Hello everyone, welcome back to my latest video. In this video I would like to talk about employment clauses while entering into employment. Now when we are all job seekers, when we all go to job interviews or enter into job contracts, when we are finally selected at job interviews for specific jobs, we are required to sign certain employment contracts. So when we sign those employment contracts, there are certain clauses that we need to be aware of, that we need to be wary of, since employers may often use those clauses to trap those of us employees who are desperately in need of a job, who would be ready to take the job under any circumstances, regardless of what the employers try to extract from us. So this video, I'll explore further about how, what sort of clauses, what sort of provisions in employment clauses we should be aware of and should be wary of. So moving on ahead. Now when it comes, now when you enter into employment, or when you are leaving your job, current job, and seeking another job, one of the primary factors is obviously CTC, as in what sort of salary package you want. If you are earning say 40 to 50,000 per month, in the next job you'd want 60 to 70,000, right? So essentially there are several legal clauses in this employment contract. So what are the purposes? So when you when you first enter into a job with another organization, the first thing you should do is you should examine the clauses properly, legal clauses. These clauses, they usually dictate how easily you can switch jobs. If you are dissatisfied with your current job, how easily you are able to switch to your next one, within how many days after you decide to resign. There you need to be sure that if this contracts, they don't contain clauses where you are trapped in that organization for an unwanted period of time. Essentially, you should first examine the contract to find out as to whether you can switch the job or not before you join up the organization. This usually is referred to as bond clauses, where employers usually bind you to the organization for a specific period of time, 1 to 2 years. So you should be wary of such clauses. Make sure you do not join organizations where such bond clauses exist. That way, if you end up being dissatisfied with the work environment, you can leave. That you are not trapped for the set period of time specified in the contract. So make sure that you are able to switch roles properly. Then this contracts also determine one of the other roles of employment contracts is, when you are with the company, you are given resources to develop products and ideas on the company's behalf. Like say if you are in the IT company, when it comes to software development, you are using the company's resources, like the company's computers and all other resources it has at its disposal to make the software, or in a manufacturing company for designing products and so on. So these employment contracts will determine, during your tenure of employment, prior to your probable termination or so on, or your resignation, who owns the rights to whatever you have created during your time with the company. If this differs, if you have created anything without the help of the company or its resources, then that belongs to you only. But if you've done anything by using the company's resources and help, then whatever you created belongs to the company only. So again, that differs. I'll explore this creative rights matter further along the video. Then another purpose the legal contract service, the employment contract service legal protections. Whatever clauses they are specified in the contract, they usually help both employer and employee to resolve any legal disputes that arise. The employment contracts, they are legally binding contracts as per the Indian Contracts Act. So if you take this contract to court, court will decide the matter of dispute on the basis of the contract, and of course on any other evidence as well. So moving on ahead, One of the important clauses you need to watch out for while entering into employment is probation period. Now, probation period means when you first enter into a job offer with a company, when you first enter into a new job, there is a test period which the company assigns to, wherein the company would find out exactly what sort of resource you are, as in how you will be able to contribute to the company's operations better. So there's a temporary period. For during this period, the company will determine just how capable you are, whether you have an aptitude for work and so on. If the company decides that you are suitable enough for the company, then they would make you a permanent employee, as in as a permanent employee you would have more rights than you would as a probationary employee. As a permanent employee, if you resign, you will be entitled to earned leaves, or you would be entitled to more pay, or you would definitely be kept there at the company for a certain period of time after your resignation. By contrast, when it comes to probation, you would be removed at any time at the company decides. If the company decides you are not suitable enough for the company. So the probation period, the standard duration is usually 3 to 6 months. Maximum is 6 months probation period after you first enter into the job. If you want, if the probation period is to be extended by the company for any reason, like say if it is 6 months normally, but the company wants to extend the probation period to say 9 months, then the company is required to serve return notice to the employee before the original term expires. Then when it comes to notice terms, as a permanent employee, your notice term is usually 30 days or 45 days or so on, but here the notice period is much shorter, like 7 to 15 days. That this is usually so that the organization may be able to let the company go, let the employee go pretty quickly if the employee is deemed unsuitable for the company. That way a company doesn't have to suffer the said unsuitable employee being in a company for much longer. So if during the probation period, the notice period after resignation is definitely a lot shorter. Then when it comes to probation period, unless and until the contract states any other conditions for confirmation of the employee as a permanent employee after probation period is over, it is usually auto confirmation. After a certain period of time, once the probation period has expired, you are automatically confirmed as a permanent employee with more rights, more pay, and with also right to take earned leaves, casual leaves, and so on. Now, when it comes to statutory rights, there have been rights under the labor laws laid down where employees have the right to provident fund from the organization, or employee statutory insurance, ESI, which usually relates to employees insurance in the event of any incident occurring against them, whether it be at work or anything relating to work, and minimum wages and minimum salary. Now these rights they are usually presumed to apply to permanent employees, but however, as per the law, the statutory rights are also applicable to employees on probation as well. Merely because you are a temporary employer, because your status in the company is somewhat uncertain, it does not mean that you are deprived of your rights to provident fund and employees insurance, and for that matter minimum wages. You have, as a probationary employee, you would be entitled to these rights just the same as a permanent employee. You may not have other rights like casual leaves, sick leaves, or earned leaves, but you would have these rights, these statutory rights which are specified here. So this is one of the clauses an employee needs to watch out for when you are entering into a job contract with an employer. Now moving on ahead. Now notice periods. Now when you are exiting a company or any workplace, you are asked to stay behind for a certain period of time, whether it be 30 days, 45 days or 90 days after your resignation. There you are asked to stay behind for certain period of time. This is largely to cover any pending work which you are assigned to do, or to train any replacements who are going to take your place and so on. Now the standard notice period is maximum 90 days. This is usually for senior roles, or if you are in an IT company or so on, there the notice period would be 90 days maximum. Then there is another thing called buyout calculation. Buyout usually means that when you are assigned a certain notice period after your resignation, like say 45 to 90 days, if you are exiting if you have resigned from your post and you are required to stay for that certain notice period, however you decide to leave the company mid notice period only for any reason, then the company would demand from you salary proportionate to the number of days which you are required to serve for, as in the balance notice period which was remaining, which you did not serve. For that the company is asked for the certain amount of salary. The formula is total salary divided by 30 into whatever number of days short was there, whatever number of days you did not, notice period you did not serve. That said, this right is 100% reciprocal, as in if the company demands, if the company pays you certain money and demands you to leave immediately or mid notice period for any reason because they really don't want you around, then you as an employee also have the right proportionate to that right. Like you could also demand compensation from the company for an abrupt exit. Like if you are being unfairly made to exit from the company for no good reason, for just because of politics or company's pettiness, so you have the right to demand proportionate salary similar to the same so to the number of days you wanted to serve, but you are not allowed to serve for any reason. Then when it comes to legal protections, now under the Constitution of India, forced labor is abolished. You cannot be forced to work. If you want to leave the company for any reason, then you are the company is obliged to relieve you. The company cannot make you, force you to stay for any reason. Nevertheless, employment contracts do lay down that you would be required to pay certain penalties to the company caused by a premature exit. Penalties usually being the buyout which I have mentioned earlier. At the same time, you can demand compensation from the company for any abrupt, unreasonable exit, or being made to exit on extremely short notice, or during notice period you were made to leave for no good reason. Then termination. Now there are two ways an employee can be terminated from service. One is for cause, one is for convenience. Termination for both of these are very different. Termination for cause, as in what is the trigger, what is the reason for termination for cause. This usually is because of any misconduct, fraud or breach of contract on part of employee. Let's say as an employee you are obliged to keep company secrets, but you somehow ended up leaking them, or you indulged in bad behavior at office where despite repeated warnings you simply carried on, then you would be terminated for such reasons. Then for termination for convenience is, this is usually done this termination for convenience has a term. It usually means when an employee is terminated by convenience, an employee is usually said to resign from his post. As in this is voluntary on the part of the employee. The employee for his own reasons has decided to resign from the company. Pardon my poor writing. Resign. So essentially, the non-formal term for this is resignation. So this is usually voluntary exit of the employee from the company for employee's own reasons. The notice period also differs here. Termination for cause is usually notice. There is no notice period usually. The termination is usually immediate, largely because the employee is proven a serious liability for company's operations. So the employer would ask the employee to leave immediately. When it comes to termination at convenience, as in resignation, this usually is 30 to 90 days notice or pay. There's largely this is usually because the company would want to make use of the employee's services for as long as necessary for the designated notice period in order to complete pending projects or whatever work was pending, or to train replacement employees and so on. Then when it comes to benefits, this is usually a disciplinary termination. So one way of punishment is whatever incentives were there. Let's say you leave, earned leaves or pay, you would not be entitled to any of those. You would be made to leave the organization immediately without pay or without benefit of earned leaves. When it comes to resignation, you would be given the full pay for notice period or full payout of whatever earned leaves had accrued during your term of employment. Then when it comes to termination or cause, this is usually done by process of inquiry. If there is any complaint of employees misbehavior, a complaint is filed with the management, who conducts an inquiry just like how it happens in a courtroom. Then they ask for certain proof of employees misbehavior or misconduct. On the basis of that, after the inquiry, the employee is terminated. When it comes to termination for convenience, however, this is by a simple written communication, simple written letter or email or message by the resigning employee to the employers. No proof needed here. Just state that you want to leave the company for whatever reason, and the employer would grant you that notice. Then when it comes to reputation, termination for cause is usually not recommended. It's best you don't incur being terminated for any cause, because this is very risky. The company after your termination could end up blacklisting you, thus preventing you from getting another better job with another company in the future. Blacklisting means you'd have difficulty finding jobs. So it's best that you do not get terminated for misconduct or misbehavior. It's best you resign from the company of your own will, because this is usually a new standard corporate practice. It's usually neutral. You are resigning of your own will, so the company would give you a relieving letter, experience letter, and on the basis of that you could seek employment with another company based on your own desires. I mean, you would be able to seek employment quickly enough or within a period of time. By contrast, being terminated for misbehavior or misconduct would result in you being prevented from getting a good job in another company simply because you are blacklisted. You are essentially listed as an unwanted, unreliable employee, unsuitable for being hired by another company. Which is why termination for convenience is usually much better than being terminated for cause, which is usually a disciplinary termination done because you are a serious liability for the company. So a simple advice: don't be a liability for your company. Try to be as productive, as disciplined, be on your best behavior while you're doing your job outside. If you want to be able to resign of your own free will. Don't let it be forced on you. So moving on ahead. Now when it comes to now there is a section under the Indian Contracts Act which usually stipulates that any agreement which puts a restraint on lawful trade. Let's say if you are entering into a contract with another party, and that party prohibits you from engaging in another lawful occupation or lawful trade for any for no reason at all, for not for any good reason, then section 27 stipulates that this agreement is usually void, and as in such agreement which puts such clauses is usually void. So the thing is, most employees are not really aware. So what happens is, when you resign from the company, employers usually put non-compete clauses prohibiting you from working for competing organizations or related organizations after you are terminated from employment. Now, however, this is usually an empty threat issued by employers when this employment clause, when these contracts have been taken to court on dispute. Courts have usually ruled that employers are under section 27, these clauses are void. Employers cannot stop you from joining competitors after you have left the organization. So usually employers, they use these clauses, these non-compete clauses, to intimidate you. Since employees usually are not aware that non-compete clauses are especially post-employment non-compete clauses are completely void, and that if you go to a court, employers cannot enforce them against you. So you should be aware, be aware of the fact that if you leave the company, then employers cannot insert these non-compete clauses prohibiting you from post-employment work with competing or related organizations. You can work for them if you want. Nevertheless, there are restraints, certain restraints are valid, like when you are with the company, when you are on the payroll of the company, if you are in the company's employment, then the employer can restrain you from working for the competitor simultaneously. If you are caught working for the competitor, you are liable to be terminated for misconduct or misbehavior, or you could also be heavily penalized for working with the competitor and essentially leaking your own company secrets to competitor and so on. So you can't work for competing organizations simultaneously. If you work for one company, you have to work for that company only. You can work for the competing organization after leaving the previous one, but not while you are with the previous one. So non-compete clauses are usually void after you leave the company, but not while you are with the company. So essentially, try not to work for competitors while you are with the company. Be honest with the company. Maintain integrity while you are employed with the company. That way, the law will be on your side if any problem occurs. Otherwise, if you indulge in corporate espionage or anything of the sort while you are with the company, then yes, the law would work against you. So be careful. So moving on ahead. Now there are certain boundaries. Nevertheless, while non-compete clauses are usually void post-employment, certain clauses are valid. What are these certain clauses? One is NDA enforcement. This usually means that when you are with the company, you are privy to certain trade secrets of the company, trade secrets, usually patented information or copyrighted information which the company had taken efforts to develop. So as an employee, you are privy to these secrets. So and these secrets and also proprietary data as in client customer client details and all of these, they belong exclusively with the company. These restrictions, they are indefinite. Even after you leave the company as a former employee, you are bounded by restrictions on disclosure of trade secrets and client data and so on. You cannot disclose them even after you leave the company. If you disclose them, you would be liable for breach of patents or breach of trade secrets or essentially breach of contract, you would be heavily penalized. So this is one exception. Another exception is client restrictions. After you leave the company, the client, your former company would put clauses restricting you from contacting or soliciting or poaching really clients of your former company while you were working with the company. However, this is not indefinite. Usually this lasts for 1 year. So for that 1 year period after you left the organization, you cannot solicit clients of your old company. You can solicit them after the tenure period specified by the company's over, but until then, no. Then another restriction which is usually valid is employee solicitation. As in, if you are going to start a company of your own or a firm of your own, then you cannot actively recruit your former case, as in the people who are still with the former company, but you are the one who's left, so you cannot recruit those employees with you while forming your company or firm. You have to seek out new people. This restriction is unfortunately valid. You cannot seek out your former colleagues in any new venture of yours. You'll have to completely start from the ground up. So there are another restriction which is valid. Then another restriction is skills versus assets. Whatever skills and knowledge you have accrued while working with the company, that you can keep for yourself. You can utilize it while you are starting your own venture or while working for another company. But the client data, client databases, or any source code or anything really, let's say secret of making a new product which you are privy to while working with your former company, you cannot disclose any of that. You cannot use any of that in your new company or while you are working as a self-employed person. Client data or any source code or any secrets pertaining to products which you are privy to while you are working with your old company, you cannot use any of those to your advantage. The company has the full right to move against you legally if you attempt to misuse any data or any secrets that you are privy to during your employment with the company for your own benefit, illegally that is. So moving on, so these are the legal restrictions. Mostly non-compete clauses are invalid, but these are the 4 restrictions which you should abide by as a former employee if you ever plan on leaving your organization. These are the 4 restrictions that you should abide by. These are the restrictions which the law has deemed valid on the company's part, which if you violate these restrictions, the company has full legal right against you to extract compensation and penalties. So be careful. Moving on ahead, then when it comes to intellectual property ownership, now when you are working for a company, let's say you are working with an IT company, you develop certain software on the company's behalf, or if you are the manufacturing company and you came up with any new ideas for products and you develop those products with the company's help using company resources. So under the Copyright Act 1957, when it comes to copyright or patents on any ideas or products or which you developed during the course of your employment with the company and which you made using the company's resources exclusively, as in all of these were made exclusively during the working hours and using the resources of your company. All of the rights to such work, they belong exclusively to your employer. You do not have any rights to any work you made during work hours using company's resources exclusively. Those belong to your employer. The employer has full rights to the work you made using his resources. That said, you have the right, while the companies do own the copyright to the work you made using its resources, you do have the moral right to be credited as the author of said work should such work be advertised to other people. You have a moral right. Though the thing is, when it comes to standard employment contracts, they require employees to waive such moral rights, which is perfectly valid. Yeah, you cannot force yourself, you cannot force the company to recognize you as the author of such work. Since the Copyright Act has laid down that copyrights on work developed with company help during company hours, they are exclusively company's right. The company alone is the author of such work. Individual authors can be identified, but that's the prerogative of your employer. If the employer chooses not to identify you as the author, then there's nothing you can do. Then when it comes to patent ownership, now this is copyrights. Now when it comes to patent ownership, they use the whatever patents, whatever work you have developed using resources, whether it be exclusively company resources, or sometimes it can be a mix of company and your own resources. They usually assigning patents to the company for work, they usually require separate assignment deeds. Essentially, in employment clauses, separate assignment deeds would be laid down, where it would be laid down that whatever work you developed using company help, that work belongs exclusively to the company. There is nothing you can, as in you will not be identified as the author of the work. That would be the company's prerogative. However, if you are developing anything outside of work hours, any innovative item or innovative product or idea you are creating outside of work hours, using your own resources, mind you, then contracts are required to exclude such work. You have the full rights to said work. The company cannot the company cannot ask for rights to such work. That work is the one which you made with your own time and resources without the company's help. So the company has no right to make inroads into your own work. So whatever work you made outside of work hours with your own resources, that work belongs exclusively to you. That company has no right to claim the credit for your own work outside of work hours, that is. Then also another precaution you should take is whenever you're entering into an employment contract with a new company, you must always disclose any pre-existing work contracts, any contract any pre-existing IP, as in you made anything or you developed something prior to entering into the company. You must disclose that fact when you are entering into employment with a new company, that you had developed this and this, and that it is patented, and that you made it on your own, and that this was done prior to your entering into the company. That way, should the company find out, they cannot claim credit for work and try to, file a patent or copyright claim on your own work, which was developed by you before coming into the company's employment. So this is again very important. When you enter into a contract with the company, disclose any property or anything you should develop prior to entering into employment with the company. That way your pre-existing work is protected from being poached by your new company. So moving on ahead. Now there are certain clauses which you should watch out for, certain toxic clauses which the employers might use to exploit unaware employees or employees who are desperate for jobs, that they overlook all these. So what are some of these toxic clauses which you should watch out for as an employee? One is unfair repayment. Sometimes if you leave an organization early, like you want to leave early for really urgent reasons, really good reasons, employers can extract employers, they often extract repayment fees. like because you are leaving early, so they demand fees for leaving early, repayment fees as is called here. Now this sort of fees, they are usually unenforceable. They you have the right to leave early for good reasons. The employer cannot force you to pay money unnecessarily for leaving early. The only way they can demand proof from you is if they supply proof, if they state and supply proof that they incurred costs on training you for the role, as in the role to which you are assigned, it requires specialized training for which the company incurred a lot of money. So if they supply proof of such training costs, then they can extract repayment fees for leaving early, because that means that they invested in you, and since you are leaving, it's a sunk investment, so they want compensation for it. Then they can take the money from you. But otherwise, in most circumstances, leaving early should not have you being forced to pay money for that. Then another is shifting terms. So again, without, unless they ask for your consent in writing, or unless they provide you advance warning, then any change to your salary amount, or to change to your role, as in if you are being punished with demotion, or if your location of employment is being changed from one branch to another, none of this should be a surprise. They should take your written consent, or they should at least provide you a warning if you have done something wrong, telling you that if you continue to indulge in wrong behavior in future, then this will happen. Then these changes will be valid. Otherwise, surprise changes are invalid. Then withheld wages. You should be aware of any illegal clauses where which claim that for some reason, or for any frivolous reason, your earned leaves are forfeited. That even after you resign, you cannot claim the amount of earned leaves, or you cannot claim salary for the notice period that you are saving, for notice period that you are serving. For any if the employer withholds payment for all of this, then you have the right to seek payment of our earned leaves or salary for the notice period you are serving with the company. The company cannot withhold the payment for this unless it is for a very good reason. Then again, as an employee, if you are working with a company, you are a third party, an outsider working with the company for a specified period of time. If there are any clauses where you are being made personally liable for business losses, make sure that you do not agree to such contracts. Be aware of such clauses where you are held personally liable for business losses, unless and until those losses have occurred because of intentional misconduct on your part which has resulted in those losses. Otherwise, if you are held liable for all sorts of business losses for which you had no control over at all, then make sure to dispute those losses in a court of law. The court will ultimately come down on your side, because these losses are clearly illegal. As an employee, you are only responsible for your own work. You are not responsible for the wider business. That's the prerogative of the management and the CEO, CFO, and so on. Otherwise, as an employee, you are not liable personally for business losses, unless those losses are really because you are the one at fault. So these are the toxic clauses which you should watch out for when you are entering into an employment with a company and so on. So moving on ahead, then so when you enter into a contract with a company, when you are joining the company, there are certain there are certain ways by which you can negotiate this contract, or you should watch out for certain bad clauses in the contract in order to protect yourself. One is you should request the draft of your contract. When you enter into an employment contract, don't sign on the first day itself. If you can, request a full contract draft from your prospective employer and at least 48 hours in advance prior to your entering into the company. If you are confirmed in an interview that you are selected for the employment, then first seek out the contract draft, study it thoroughly. For 48 hours prior to your first day of the job itself, seek out the employment contract and study it in detail. Then once you get the contract, cross-examine the contract completely, cross-check how much notice period you are required to serve in the event of resignation, what sort of role you exactly been assigned, then what is the variable pay. Sometimes mostly pay is fixed, but sometimes pay can also be variable depending on certain terms and conditions. Let's say when it comes to bonus, or let's say depending on your performance. So check out all these terms in the contract and check it against the offer letter that you received from the company at the time of joining. Cross-examine what's there in the contract and what's there in the offer letter. If they do not match, then make sure they match. Make sure you put the contract before the company and renegotiate it, or change the terms such that they suit the offer letter or they suit whatever it is you want. Essentially just negotiate the contract to get the terms you want. Then third step is seek reciprocity. So if in your contract is stipulated that for your role after your resignation you are required to serve 90 days notice period with the company, then from the firm itself negotiate a matching 90-day period, as in negotiate that, as in essentially if you are going to, if the company demands that you serve 90 days, then if you decide to resign, make sure the company doesn't terminate you mid notice period. Essentially make sure that you are able to serve the 90 days notice period if you want to, that is, or if you are forcefully terminated before the notice period is over, then make sure you get the compensation equivalent to the notice period that you are unable to serve, if the termination is without cause, good cause, that is. Then another is clear activities, as in if you are going to perform any outside activity, if you are going to do any side ventures by which you are earning money, often there are times when the company would find out an object to said activities. So get written permission if you are doing any side hustles or side activities by which you are earning money, outside activities, that is. That way, if the company finds out and decides to dispute it in a court, at least you have the protection of having gotten permission from the company. Otherwise, this could end up becoming a long legal dispute in a court of law. So get permission if you are going to do any side activities or side businesses outside of your employment with the company. So essentially, to summarize the video as I stipulated earlier, first thing is when you are entering into a contract with the company, verify the notice period. Verify how much notice period are required to serve with the company if you want to resign from your role in the company. Then also examine the buyout clause terms, that is on what basis you are required to pay any compensation to the company if you want to leave mid notice period, or on what basis the company is has a duty to pay compensation to you if when you are made to leave mid notice period for any reason, if the company forces you out. That way when you verify all of this, when you are made to resign unexpectedly for any reason, that way you avoid any potential liabilities on your own part. Then when next is non-compete policy. Now, as I've said earlier, if there are any clauses where you are unnecessarily restrained from employment with competitors or any other organization, ignore those clauses. Nevertheless, when it comes to company data, company secrets which are very sensitive, which are required to keep confidential, respect that confidentiality. If you do not respect it, then the company has the full legal right to move against you and could even extract penalties from you. Then when it comes to IP ownership acts, another way is to make sure that whatever side projects or products or any ideas you are working on or any side businesses you are doing, make sure that they are completely separate from whatever it is you are doing for your company. Make sure that you do not mix company resources and your own resources while working on your own project. Use company resources exclusively for company projects, and when it comes to your own projects, use your own. Don't mix them. Otherwise, if the company should the company lay claim to all to any side businesses or side projects you are doing, and if it is found out that you have mixed company resources and your own, there could be a long legal dispute stating which part of your project belongs to a company, which part to you, or whether it belongs entirely to the company or to you. It's a long legal dispute. The company might end up winning the legal dispute because of its more significantly higher resources. So make sure also, so make sure that you keep your side projects and company projects separate. Don't mix them. More importantly, whatever projects you done prior to entering in the company you did on your own, disclose them while entering your new job, so that the company does not poach on your pre-existing projects and doesn't unnecessarily benefit from your own efforts, from the efforts that you made without company help. Then termination clauses. Then when it comes, then you need to examine the termination clauses pretty well. Make sure that whatever when it make sure that what sort of termination is occurring in the company, whether if you are unlawfully terminated for no good reason, what sort of compensation you can expect from the company legally, or if you are resigning from the company voluntarily and are required to some notice period, how much money you can take from the company, how much pay you are entitled to from the company in terms of salary or accrued on leaves and so on. Make sure you clarify all of this with your prospective employers prior to joining the company, and make sure all of this is explicitly laid out in your employment contract. That way you are legally that way everything, if it is properly laid down in the contract, all of this is will ensure your own protection. So to conclude this video, make sure that your employment contract serves as a tool for your growth, not as a prison where you are imprisoned with one company and that company inserts unnecessary clauses which are illegal or which serve to keep you in that company only for an unduly long time, where your career growth is stunted. So essentially, when you enter into an employment contract, have the contract ready with you, examine it closely, take the help of your known legal counselor in order to find out what sort of, whether any clauses, any problematic clauses there in the contract which would hinder your work in the company, or which could hinder your potential exit from the company for any reason. So one way is to try to master Indian employment laws. If not master, obviously you would not have time for researching Indian laws. So take the help of your legal counselor in order to find out more about how Indian employment laws work when it comes to employment in companies or other firms and so on. So essentially, be aware of Indian employment laws, at least in the common in lay language, in common language, not too complicated. You don't have to be aware of complicated stuff. Just be aware of the simple stuff while you are entering into the contract. Then when it comes to safeguarding your autonomy, review the non-compete clauses. Make sure those non-compete clauses are reasonable and that they are not illegal or unduly encroaching on your right to free trade and occupation. And essentially review your employment contract thoroughly, seek your legal counselor's help, and only after reviewing the contract thoroughly and after negotiating it to your own advantage, only then join the said company, and join those firms where your professional rights as an advocate, professional rights as any employee, not just advocates. I am an advocate, of course, but not just an advocate, but as any employee really, whether it be as a whether it be as a manager in manufacturing or really any role really. Your professional rights, your career, your rights in that organization as an employee are completely respected. So thank you all for watching this video. I hope what the contents of this video help you, those of you who are job seekers, those of you who are about to enter into employment with companies, to be aware of any potential abuses on the employer's part and to help protect yourself. At the same time, be aware of your boundaries when it comes to work. Don't try to cross those boundaries. Essentially, don't give your employer any just cause for moving against you or for extorting any penalties or compensation from you. Safeguard yourself properly, be aware of your rights, and at the same time be aware of your duties. Balance your rights and duties so that you are properly legally protected. So once again, thank you all for watching this video. Please please comment, like, and recommend this video to anyone else you know. Please also subscribe to my channel at Siddharth but 4898 where this video is right now, and recommend that channel to anyone else you know as well. Once again, thank you all for taking out your precious time to watch this video. I sincerely hope this video helps fruitful, helpful to all of you, especially those of you who are job seekers. So thank you all for watching this video. Thank you all. Thank you. Thank you.